Any mention?
Yes, Mr. Hajarika.
May I please, Your Lordship, item number 5, my Lord. Then I have prepared synopsis in order of chronological event, but I think that some document I have to enclose, because all the documents, some are writ petition, some are affidavit in opposition, some are in additional affidavit, my Lord. So I require.
For preparing synopsis, you do not have to enclose documents there.
No, because of last time Your Lordship has that the
What
document.
we wanted that you place this in chronological order.
No, but document are in the different editions. So I will enclose along with that, so it will be convenient for the honorable court. So it may become after puja, my lord.
Okay. After 2 weeks, on the request of the learned counsel or the petitioner.
Much obliged.
Lordship, I want to beg to mention item number 14. I need 3 weeks time, Your Lordship.
Item number 14. You are for the petitioner.
Yes.
Other side?
Well, for the state, my lord.
Okay. When do you want it?
3 weeks, Your Lordship.
Okay, item 14. On the request of the learned counsel of the appellant. After 3 weeks.
Obliged, Your Lordship.
May I please, Your Lordship? I'd like to mention item number 6.
Item number 6. Yes.
I'm praying for 2 weeks time, Your Lordship. Yes.
You are for the respondent.
Yes.
Lordship,
Respondent 126.
I'm from petitioner, Your Lordship.
What is this? This is Aking.
Gaunpura Mata, Your Lordship. Removal of the petitioner.
These are all 2017 matters. Why you are asking time?
Because the conducting counsel is not available, Your Lordship.
6 and 7 is similar, Your Lordship.
Number 6.
Any objection?
No, Lordship.
6 and
7.
both are similar.
Yes, Lordship.
No, sir. The Sculpture matter
It's connected
is...
matter, Your Lordship. 6 and 7.
In fact, by mistake, it's been tagged together. So one relates to a Gaunpura matter and one relates to a land matter.
Lordship,
Why you
Cancellation.
did not get it released? If it is tagged together.
Lordship,
If it is tagged together, you should have got it untagged. You should have.
I'm appearing today for the first time in this matter after it's come from the other court.
So your prayer is for 6.
For 6 and 7, Your Lordship.
Any objection from any side? Okay, 6 and 7. Both on the request of the learned counsel. Or the respondent number?
Respondent number 123.
In both the cases.
No. In item number 6, for respondent 126, and in item number 7, respondent 123.
Yes. After 2 weeks. Okay.
Most obliged, Your Lordship.
Lordship, please, Lordship, I beg to make a mention for item 16, Your Lordship.
Last item. Yes.
Senior counsel is not keeping well, Lordship, so
This is a matter you can do it.
I have not
This is
instructed.
a quashing matter, isn't it?
Yes, my lord.
Actually, Lordship, here is the respondent 3
No objection, my lord.
appearance.
16. On the request of the learned counsel of the petitioner. After 2 weeks.
Highly obliged, Lordship.
May it please, Your Lordship.
Yes.
Lordship, I beg to make a mention of item number 11. My Lord, I pray for some time since the conducting counsel is not prepared, not ready. No
Was it
objection.
that matter, Mr. Nonkla, which was hard at some length? That was.
Yes,
Is it a service matter? Promotion?
No, not that one, Lordship.
There is
This one
different-
is another. No,
Another one, Lordship.
it's a different matter.
Different matter.
You have any objection?
No objection.
You are for the state.
Yes, my
I'm
Lord.
appearing for respondent number 7.
Who is the number 7?
MPSC, Lordship.
MPSC. It's a selection.
No, this is in connection with the recovery of the excess amount paid to the petitioner, Lordship.
Achha. Okay, on the request of the Learned Council, on the round of the Learned State Council. This is matter after 2 weeks. Item 11.
My lord, assembly prayer for item number 13. My lord. The private respondent. Mr.
Who's the
SN
other
is
side?
not ready, free for some time.
Who is the other side? Item 13.
I'll inform the other parties.
No one is there. You may inform, but then if they have objection, wait for some times. You can mention it when the matter is taken up.
Much.
Yes.
My lord, I beg to make a mention of item. My lord, item 12 of the hearing list, my lord. For the petitioner.
Yes.
I'm for 1, 2, 3. Your Lordship.
I'm praying for adjournment, my lord.
He has not made any prayer.
I'm praying for adjournment in this matter, my lord.
I think this can be disposed. This is a disputed question of facts, in fact. That's right.
No, nevertheless, my lord, it's a question of leave. Cantonment, my lord.
So what can?
It's difficulties.
Okay. 12 after 2 weeks on the prayer of the Learned Council of the petitioner.
Right. God bless you.
Please, Your Lordship, I beg to mention item number 8, 9, 10,
8, 9, 10.
13 and 15, Lordship.
All in one shot.
Yes, Your Lordship.
8 to 10 are connected, Lordship.
Huh?
8 to 10 are connected matters.
8 to 10 are connected matter. Then what remains in the case? These are what? All these are quashing applications.
Yes, Your Lordship.
Question.
Here for the petitioner.
Yes, Your Lordship.
Okay. 8, 9, 10. And the request to the Learned Council of the petitioner.
For 2 weeks' time, Your Lordship.
Just after 2 weeks. 8, 9, 10. Only.
8, 9, 10, 13 and
13. 13 just now who mentioned? Who was there? State Council. See. 13 you are mentioning now. When do you want it? This is 22 matter.
Join, Your Lordship.
2 weeks on the joint request of the parties. 13. List after 2 weeks.
And 15, Your Lordship.
15.
Yes, Lordship.
For 15, Lordship, I'm for the respondent.
Okay. 15 also on the request of the petitioner. After 2 weeks.
Thank you, Your Lordship.
Supplementary list. Item number 1.
Yes.
This is a similar matter wherein your Lordship has also earlier passed an order which regard to the incident of Mini Secretary at Tura, Your Lordship. Here the petitioner herein is a lawyer practicing since 2013. She was practicing in Shillong, then Yoru Hills, and Guwahati also. What happened, she happened to be an unregistered one organization, Achik, by the name Achik.
It is that matter. There is also another matter, I think.
Yes, Your Lordship.
Yes.
So, Your Lordship, in fact, I'm praying because she is a practicing lawyer, and she was with the Chief Minister at the time of the occurrence. And
Why,
she was,
then why there is an allegation against her?
no, allegation, what happened, in fact, those who were arrested, she took out them also some on bail. Then later on, what happened, after the Bernard Marak was released by interim order of this Honorable Court, Your Honor, then police went to her house. That means the reason that she want to protect herself, that she want to give a statement to the investigating officer, but to avoid the courtship action, she is moving this criminal rate, Your Honor.
Is she named in the FIR?
No, not named in the affair.
Will call for the CD. We'll just see what.
Just the interim. Authorize is a practicing lawyer that being the reason, Your Honor.
No, but then you have approached after so many days. What is the fear?
No, apprehension means what happened. Recently only when it went to her house, she was in Guwahati that time. And as an abandoned precaution, she wanted to take
It was in the month of July. We'll just would like to see the CD before we pass any order.
In the meantime, some interim protection may be given, Your Honor.
Because normally in this kind of incident, it is not proper. See, only except the earlier matter also the case date was produced.
Yes,
it was.
I've seen
before the interim order was passed.
Yes, I've seen that.
So here also, I think at least we would like to ascertain what role you play. We'll have a short date. We'll have a short date. As your lordship. Be produced. When can you produce?
Let it be by 19, Lordship.
19th.
Lordship.
As your lordship.
Heard Mr. SP Montal on its person. Also Mr. Adi Shulai and Rest AG. Mr. Shulai shall produce the case diary on the next date.
Lordship.
List is matter on 19th.
Obliged, Lordship.
Item number 2.
Deeply obliged.
Yes.
Lordship, on the request of learned DSGI Lordship, if this matter can come up at the end of the board.
Okay.
Lordship.
Highly obliged.
Item number 3, hearing.
Yes, Mr. Shulai, we are
Lordship.
supposed to.
Yes, I have the. I have brought the case.
We do not need case diary. We just want to see the FIR.
Lordship.
If you
yes.
can furnish the copy of the FIR, because none of the parties
Lordship,
have brought into the records.
If Lordship, I'll just make a small submission, Your Lordship. Lordship, the Lordship, the copy of the documents, the FIR, Your Lordship. I have
Yes.
black market, Your Lordship.
Can we have a copy? See, we do not want the whole series. Can we have a copy? If it is not very bulky, just give us a copy of that.
Then I'll have to Xerox it, Your Lordship, because
Can you supply me?
yes,
me.
I'll Xerox. If Lordship, can you? This is the document annexed in the FIR, Your Lordship. Lordship, can you
The
come?
petitioner should have enclosed a complete set of the FIR. Right? Why it was not done?
Lordship, can you
We
see?
were seeking quashing.
With leave of this Mr. Mishra, yesterday we had the records inspected at the Court of the Learned Magistrate. There are no annexures to the copy of the FIR
In the court means?
in the court below for the Malad Magistrate. Copies to be
Yes.
to the magistrate court, where we obtain the certified copy. Malad, there are no annexures to that copy of the.
So that must be that must be the original FIR. If it is not there,
the original FIR doesn't have the annexures.
so is it this
That is
Mr.
our instruction.
Mr. Shula? You are referring to these documents?
Yes.
Whether these are part of FIR?
Lordship, yes. That is part of the FIR, Your Lordship. Lordship, can you see? Page 18, Your Lordship. That is the FIR, Your Lordship. 18 of the petition, Your Lordship.
Page 18 is some tabulation. Oh, what is?
18 of the petition, Your Lordship. 18 of the petition, not
That
of
is
this,
all
Your
right.
Lordship.
That
That
is
I'll
all right.
come later on, Your Lordship, not now.
No, see.
Kindly, Lordship, kindly come to page 18 of the criminal petition. That is the annexure 2, Your Lordship. Lordship will see in paragraph 5.
Yes.
Lordship has got it.
Yes.
Lordship, kindly come to next page, page 19, paragraph 5.
Yes.
There is a mention of a letter dated 20th/5/2021, Your Lordship.
Yes.
Lordship. Then, if Lordship kindly come to the blue binding, Your Lordship, that document which is part of the FIR, Your Lordship, will find it at page 136.
No, but then if it is attached and enclosed with the FIR as annexure E, why it is separate?
Lordship, because in the because the lower court record has not been called. This is the case diary, Your Lordship. This is the copy of the case diary, Your Lordship.
We will have to go through the FIR. I do not know. Now it becomes very suspicious. Why those documents are not available? Neither the
Lordship,
petitioner
if
nor,
that be,
nor
if that,
even the private respondent.
If that be, no, Your Lordship, that has been mentioned in paragraph 5 and annexure E of the FIR. Lordship, kindly have a look at page 19, paragraph 5 of the.
Yes, the copy attached as annexure
that
E.
has been copy attached as annexure E. Annexure E, Your Lordship, that is the.
That means it is attached with the FIR.
Lordship, yes, it is attached with the FIR. Copy attached as annexure E.
Yes. So where is that? See, where is that annexure E? Why it is not as annexure E here?
Lordship, they have not enclosed it, but yes, Lordship, kindly see that is copies attached with the FIR, Your Lordship. Lordship, kindly come to page 136.
The case study was called for that purpose, the sole purpose. Otherwise, court has no business right now to go to.
Lordship, kindly have a look at page 136, Your Lordship.
Yes.
Lordship, this letter, Your Lordship, is either forged or false.
No, this I can understand that.
Yes, Your Lordship.
What we wanted to see is that whether it's a part of FIR or not.
Yes, Your Lordship, it is a part of the FIR.
What basis you say?
Because, Your Lordship, that has been mentioned, copy attached as annexure E, Your Lordship. It's part of the FIR, Your Lordship. Yes.
That is one document. What
Yes.
about the other documents?
I'll come
FIR
later.
refers to other documents.
I'll come later.
But then these are all kept separately, isn't it?
Yes, Your Lordship, because
this court is basically interested in perusing the original copy of the FIR.
then if that be the case, then the Lordship, the record, the LCR will have to be called, Your Lordship. Can you see, Your Lordship, that that letter which is
These copies of documents are otherwise here also.
Lordship, yes. Why, Your Lordship? This is why I submit, Your Lordship, that this copy is either forged or false, because, Your Lordship, at that particular time when Mr. Ramesh Bansal signed on 20th/5/2021, Your Lordship, he has not joined the company of the petitioner.
And that is
He
exactly
joined
the
on
submission which was made by the
Yes.
counsel for the private respondent.
He joined only on 27/8/2021, Your Lordship.
And that is precisely the FIR also says that,
Yes,
isn't
Your
it?
Lordship. Then what happened, Your Lordship? After this FIR had been received, Your Lordship, a case has been registered, Your Lordship, and the investigation commenced, Your Lordship. Commenced, Your Lordship, and a number of documents were seized, Your Lordship, by the police, Your Lordship.
These are Caesar.
Lordship, yes. Because
These are the documents.
Lordship, then Lordship, kindly come to page 67 of the petition.
Why you are taking into all those things? See,
Lordship,
Mr.
because what happened? This letter are alleged to have been forged, Your Lordship.
No, that is all right. We are not going into all those things. We just want to see whether FIR prima facie discloses any of this.
Yes, Your Lordship.
We are not going for determination of the correctness and truthfulness
In
of
my
the
humble
FIR.
and
and all
respectful
those things.
submission, Your Lordship,
We are not.
a prima
this is not
facie
our-
case under section 467, 471, and 469 of the Indian Penal Code had been made out, Your Lordship, during the course of the investigation, Your Lordship. And the investigation, Your Lordship, is still going on. It is in the infant stage, Your Lordship. infant stage, Your Lordship. In fact, Your Lordship, page 67 of the petition, which they have annexed, Your Lordship.
Yes, yes, continue.
And the document seized by the police during the course of investigation at serial number 16. Can you have a look, Your Lordship, at serial 16 and page 67 of the petition, Your Lordship? There is a difference of signature, Your Lordship. Can you have a look at page 67, Your Lordship?
Page 67 of the?
Of the petition, Your Lordship. Page 67, Your Lordship.
Yes.
Authorized signature, Your Lordship, to the left side. And Lordship, kindly peruse serial number 16 of the blue book.
There are two, both are blue books.
The second one, Your Lordship, that is Annexure 25. These are the documents seized from the PHE department.
Page?
No, Your Lordship, serial number 16. I have flag mark, Your Lordship. Or Lordship, for the convenience of the Honorable Court, Your Lordship, I can make a comparison, Your Lordship. I can stare up from this, Your Lordship.
Is this the same document?
Lordship.
You are referring to the seal on the...
Yes, Your Lordship. Can you see the signature, Your Lordship?
Yeah, bill number is same.
Yes, Your Lord. Can you see the signature, Your Lordship?
Now, this is the document seized by the police.
Seized by the police, Your Lordship.
And this is the document?
Annexed in the criminal petition, Your Lordship.
By the petitioner.
Yes.
So this is a document which has been brought in by the petitioner.
Yes, Your Lordship. And that is the what in the blue book, Your Lordship. That was the document seized by the police during the course of investigation.
This seizure was made from where?
Lordship, can it come from the first page, Your Lordship? Then you will see that, Lordship. The first page was seized by the police, Your Lordship.
It was submitted by the executive engineer PhD.
Yes, Your Lordship. Then, Lordship, kindly come to...
No, it doesn't say where is the list of documents here. He has only written a plain letter. But then he has...
All these are the documents seized.
On what basis we presume that these documents are given by...
A number of documents have been seized, Your Lordship. Number of documents have been seized.
That is all right, but then where is the seizure memo? There is no seizure list.
Lordship, yes, this is a part and parcel of the case diary, Your Lordship.
Where is the seizure list? Where is the seizure list? Show us, point out where is the seizure list.
No, Lordship, this is Lordship. This has been forged by the executive engineer.
That is, but then see, he has not given. Is there any list enclosed with his letter?
There must be
list of documents.
There must be a list, Your Lordship.
Where it is? If you say must be, then show us.
That I have not taken because this is all only the relevant part of the. But these are part and parcel of the investigation.
I don't know. There are. I do not know the manner in which it has been maintained is not very correct. I don't think the case diary should be maintained like this. Case diary should.
No, I have the case diary also, Your Lordship. I have also the case diary with me because this is documents, Your Lordship. So it has been bind. It has been bind like this, Your Lordship. This document, Your Lordship, that serial number 16, Your Lordship, shown the signature of one Umang, Your Lordship. Umang Dhadhan, Your Lordship. This signature also has been denied by him, Your Lordship.
So these are all so far as the.
Then, Lordship, kindly come to page 86 of the criminal petition, Your Lordship.
Yes.
Lordship, this document, Your Lordship, this document, Your Lordship, this document, Your 86, Your Lordship, this document, Your Lordship, is not available in the record of the PG seized by the police.
Maybe. See, like these are part of FIR or what? No. The
Lordship,
documents which you have referred to earlier, also page 67.
After the investigation comments, Your Lordship, what happened? Then they asked him, Your Lordship, he made a supplementary FIR on 22/6/2023 and pushing all these documents, Your Lordship. And this supplementary FIR has been made part and parcel of the original FIR investigation, Your Lordship.
There is a supplementary FIR also.
Lordship.
I'm led by
No.
we are not aware of any supplementary FIR. I'm not even aware of any provision in the CRPC for such a.
No, but then that was not the submission given by on the last occasion. Private respondent also did not submit it. When we heard the private respondent.
No, he mentioned, Your Lordship. He did mention yesterday.
Was it?
He did mention yesterday regarding the supplementary FIR. The counsel for the private respondent, if I'm not mistaken, he did mention.
My Lord, may I take the indulgence of this
Yes,
court?
please, Mr. Bhuya.
The last occasion when I made my submission, yes, when I have made my submissions, my Lord, I have taken, my Lord, is limited to regard the contents of the affair, whether these documents are available or not. That was the query, my Lord. And if I can prima facie satisfy to this honorable court, from the affair itself, that has been before the court, and learned PP has taken this honorable court through the contents of the affair itself, and that is Annexure E. And that is a document which I have annexed in my affidavit in opposition, my Lord, at page 15. That is dated 25/2021.
Yes.
Now, this document being part of the affair, my Lord.
No, that is all right. You see, Mr. Bhuya,
document on 25/2021.
See,
Yes.
Mr. Bhuya, Mr. Bhuya.
Yes. So
we just wanted to see. Wanted to see the FIR exactly in the order in which it was filed. You see, not that you see the contents of the FIR remains in one place. These annexures are somewhere else. Now, what this FIR itself has referred to certain annexures. So, by the normal presumption, those annexures should be appended with the FIR. Now, neither the petitioner nor the private respondent has brought into the record. Now, which way the court will assume what are the documents appended with the FIR?
The court, the base rule that is being, my Lord, has to be adopted is this, my Lord, that when an affair has been lost, my Lord, along with annexure issues, my Lord, that annexure becomes part of the affair. Now, as per the CRPC provisions, my Lord, it has to be sent to the court, and the court will make a remark of seal, my Lord. Now, in some cases, what happens, my Lord, with annexures, my Lord, police doesn't know with regard to this, and that is a shortcoming, that they send the affair, but they doesn't send the, my Lord, annexures. But that's an incomplete thing, my Lord. They should have sent everything, my Lord.
No, that is what we want to see.
So that's been one part, my Lord. And that, my Lord, original affair and everything will be in the case diary. Because the skeleton, my Lord, is in the affair.
The case diary has been produced now.
In the case.
It is not there.
Yes.
And it's not in the lower court record.
No. This is part of the FIR, Your Lordship.
This is a part of we want the FIR, the whole entire, the entire FIR, as it is, as it was filed.
With the annex.
That is what this court requires it, that no other document, Mr. Shulai.
Absolutely. And yes. No, my Lord, will kindly see and accommodate to me that extent, my Lord. When the switch of investigation has been switched on. Now, during investigations, my Lord, it's been the rule of law, has been laid down by the Supreme Court and at many occasions. That it is not an encyclopedia. The informant or otherwise in a given situation, my Lord, suppose a person dies, my relative dies, I do not know the unknown person. I cause an affair without the name. Subsequently, I come to know. My Lord, I can inform the police with regard to this. And that is part of the affair, my lord.
That is
And
all
with
right. You see,
regard
what we are not going to that
appreciating the
extent. See,
affair-
Mr. Bhuya, there is no dispute with regard to all those.
Yes.
No, but then what we wanted to see, the original FIR which was filed,
The original
the
affair
very
and the-
first instance, which specifically stated that there are some enclosures appended to it. Now we wanted to see
Yes.
that one.
Yes. So my
It is
lord-
not that you see, like you are prevented from bringing in certain other records. The court is not saying that. You can do it
Yes.
at the later stage, even at the stage of investigation and all. Okay.
Yes.
But then we have not gone that far. As you understand very well, we have limits of jurisdiction in quashing. You see, we cannot go into everything. So that is, see, what we want to see is the FIR, nothing else.
Yes.
FIR
So
as it
my
was
prayer
filed.
would be to the learned PP, my lord, produce the original affair along with
That-
A,
that-
B, C, D, E, F, G, H.
That is
Now,
what
if
we are
that-
trying to take
if that
assistance from him.
contains-
See.
Yes.
Lordship, in
And
fact-
if that contains that annexure E with regard to that false document, that itself is finished. It's open and shut case, my lord. Subsequently, what has come into the record during investigation, it's a matter of investigation. So if that false documents comes in before this honorable court and it's been part of the affair, and that is the end of the matter, my lord.
Yes.
And can you produce this original affair with the annexures, my lord? That's all.
Lordship, the FIR is already there in the criminal petition, and those annexures, your Lordship, these are the annexures. Because they have not enclosed, that's why we have brought these are the annexure. Annexure 2, these are the document attached with the FIR. These are the
how
documents.
do
your
court
Lord.
determines that? See,
These are part and parcel of the FIR, your Lordship, lodged which commenced the investigation, your Lordship.
see, it is.
I have shown your Lordship that page 136, your Lordship.
That is okay.
That
That is-
also
that is-
annexure E. That has been mentioned in paragraph 5 of the
That is one of the
FIR.
documents. It is one of the documents.
Yes,
You
your
see,
Lordship.
that was mentioned, but then whether it was at all appended to the FIR at the time of filing or not.
Yes, your Lordship. Yes.
One,
Yes,
one
your
what
Lordship.
basis court determines it? See, if it is a part of record, the record should speak it. It is not that you say
Yes, your
you.
Lordship. These are the records, your Lordship. A police will not.
So that is so. Where is the FIR? It is, see, the FIR. The copy of the FIR is not kept in the order which it was filed here.
Lordship,
See, these annexures are scattered here. You have kept it in different ways.
No, your Lordship. These are the documents which form part and parcel of the FIR, and then your Lordship, annexure 25.
Is it kept in the same order
Yes, your Lordship. Yes, your
in
Lordship.
which this FIR was filed?
Yes, your Lordship. A, B, all this, your Lordship. Yes, your Lordship. Yes. Yes, your
This is
Lordship.
the copy of the FIR.
Yes, your Lordship. This is a part and parcel of the investigation, your Lordship. Can you have a look at page 136, your Lordship?
No, just let us come first. Where is the FIR? Then? Start with what page?
FIR have not brought it there, your Lordship.
So that is what Mr. Sulai. The FIR is not there. Then which way you say these are documents appended to FIR?
What I mean is,
If FIR is not there, the court wants to see it in the order which it has been filed. Repeatedly, the court is telling that.
then if that be your Lordship, then I'll produce, your Lordship, the whole thing along with the record.
Yes,
All
yes.
the record will have to be called, your Lordship.
Now, what happens? Say, supposing if you file your application, apparently basing on some forged document, can you entertain your application?
First of all, my lord, he's given a list of my lord documents which are apparently forged. I'm led by
Yes, but then I do not see him here.
That is the difficulty, my lord. I'm in a quandary. Well, I'm reading the matter. I can address my lord.
See, normally it is not for the court to see.
My lord, kindly appreciate.
Kindly, just bear with me. Any of the documents brought in by the accused, this court should not look at it while deciding for it.
Well, may I? Permit. Well, what is the allegation in the FIR? That I have used a false document. My lord, where have I used it, my lord? In Howrah. Before the court.
See,
in
this
Howrah.
was argued
What
by
is
the
that false document, my lord?
yes.
No,
Here
my
I
lord,
think
my lord, what is
senior
it?
counsel
May I?
senior counsel is there. See.
Oh, there.
Yes.
Am I to begin, my lord?
Yes, it has been projected that your petition is based on some.
Am I audible?
Not my. No, my. Sorry.
No, this is
My
a
petition.
document. The document at page 67, which you have annexed in your washing application. The learned AG here contends that this is a forged document. Could you hear me, sir? Am I audible?
My lord, I can hear, but I think my learned friend was arguing, so I did not say. If your lordship permits me, I can make my submission and then answer whatever your lordship's query is.
No, we want your reaction. You can make your submission with regard to that.
Yes.
No.
Should I start from beginning or first?
No.
Query?
This is you do not have to start from beginning. What has been contended.
Beginning of the reply to what they have argued, not from beginning. I will not repeat everything.
Achha.
Then, Lordship, I have some more submission, Your Lordship.
One by one, I will explain.
Yes.
Lordship, as I have submitted, Your Lordship, page 86 of the annex in the criminal petition, this is not available in the PHE records, Your Lordship, seized by the police. Then kindly turn to page 87,
Is it a document LS2 have been a part of the PHE record by them?
Lordship?
This page 86, whether the petitioner claim that this is a document which
yes, they have enclosed it, Your Lordship. Kindly
that is okay. Do they say they have enclosed it of their own, or do they say that they have submitted it to the PHE, or they have
a PHE does not have this document, Your Lordship.
This what document is this? Page 86.
This, Your Lordship, this is Lordship, kindly see the address to the executive engineer, commercial invoice for payment.
So this is a false document.
Lordship. Then Lordship, kindly come to page 91.
Those are the documents, I think, on the last occasion also.
This document, Your Lordship, to the left side, Your Lordship will kindly see the signature is different. And Lordship, in the document seized by the...
We'll just say this is according to you, this is also forged.
Lordship, either forged or fake document, Your Lordship.
So, but then this is available in the... Achha, this is definitely available, that is why you can compare.
And Lordship, serial number 14, serial number 14 of this, Your Lordship. Lordship was signed by one Debjit Saikia, Lordship. Can you see, Your Lordship? Can you see, Your Lordship?
Yes, this is what? This is...
Say, 91, Your Lordship. Can you see?
Achha, this is
to the left side, Your Lordship. To the left side in the page 91 of the criminal petition, Your Lordship.
Yes.
Can you see the signature, Your Lordship, and the signature in the document seized by the police?
But then here the amount also is different.
That is what, Your Lordship.
No, anyway, which way will determine this is what is true.
This, Your Lordship,
there is a difference, but then we cannot say that
it's either forged or...
No, which one?
This 91, Your Lordship, which have been enclosed in the petition.
Yes, if it is compared with the official record of the PHE.
Yes, it's forged. It's forged or fake, Your Lordship. Can you see the signature, Your Lordship?
It's okay, it's apparent, it's very apparent.
Then, Lordship, kindly come to page 92. 92, Your Lordship. In the petition, Your Lordship.
Yes.
'92 of the petition, Your Lordship.
Yes, proceed.
Then, Lordship, kindly come to serial number 18 of that blue paper. Blue binding, Your Lordship. Serial number 18.
Yes.
Lordship, kindly see the signature in the documents, Your Lordship.
No, even the document also it's different itself.
Your Lordship.
Though it is issued under same memo number,
Yes.
it has that same.
The signature, can you see, Your Lordship? So this. Whether on the basis of all these documents, Your Lordship, whether a relief can be granted, Your Lordship.
Anything more you would say?
Lordship, my humble and respectful submission, Your Lordship. As I've submitted, Your Lordship, the investigation, Your Lordship, is going on, and during the course of investigation, Your Lordship, it reveals that prima facie offences under Section 467, 469, and 471 of the Indian Penal Code have been made out, Your Lordship. And Your Lordship, this is
467, 471, and
467, Your Lordship, 469, and 471, Your Lordship, of the Indian
469
Penal Code
also, and 4?
made out, Your Lordship. 471, Your Lordship, have been made out, Your Lordship. And Your Lordship, so the investigation is at the infant stage, Your Lordship.
You said already made out, and then you say again infant stage.
Lordship, from the basis of this document, Your Lordship, this document prima facie,
Infant
Your
is not at the, this is nearing end.
Lordship, it's going on, Your Lordship, because we have to do so many things, Your Lordship, which I'm not going to disclose, Your Lordship, because that is.
There is no question of disclosing, but then once you say that offence under 467, 469, 471 has been made out, then again you say the investigation.
So far it appears prima facie, Your Lordship. Based on all these documents, it appears, Your Lordship.
Okay. Hello? You have some more thing? No.
Lordship, if Lordship allowed me, I'll place some case law on that.
Is it required?
Lordship, because Lordship, prima facie.
With regard to the limited scope.
Lordship, yes. Lordship is aware of the scope of the
On the other day, the counsel for the private respondent has placed before that Niharika's judgment.
Lordship, I'm also Lordship would rely in paragraph. I would rely, Your Lordship, in paragraph 49 of that judgment. May I submit again, Your Lordship, that judgment?
No, it's okay. That was there already. Yours is para 49.
49, Your Lordship. Then it goes up, Your Lordship.
Some case.
Lordship, before I come to that, Your Lordship, Lordship, the relevant paragraph so far 42 is concerned, Your Lordship. It will start from paragraph 30, Your Lordship.
30.
Lordship,
That way you have to read the whole judgment.
Yes, Your Lordship. May I read?
No, it's all right. How much you will read out? You can, if you want to highlight on something, you can point it out.
It goes on, Your Lordship. In this.
Sir, can I have the citation?
Yes,
Can I have the citation?
Yes, please. Yeah.
Yes, yes, sir. That is 2021 SSC online.
Name of the party?
Page 315, sir.
Just give me the name of the party, sir.
Niharika Infrastructure Private Limited.
Yeah.
Then, Lordship, another.
What? Supriya Jain?
Yeah. No, this is, Your Lordship, If Lordship kindly come to page 30 or paragraph 30 of that judgment.
Wait, Mr. Shula, I'll just.
Para 30 at
Yes.
page.
Just hold on. Just for a moment.
Lordship. Para 30, Your Lordship, at page 590.
The last page. Okay.
Lordship,
Yes.
this is Binod Araku Banchi.
Yes.
May I read it, Your Lordship?
Yes. What does it say?
It is. It reads like this. Your Lordship. It is a settled legal proposition that while considering the case for quashing of a criminal proceeding, the court should not kill a stillborn child. An appropriate
These are settled proposition, Mr. Shula. I don't
Lordship,
think.
yes. These are.
There are many judgments on those things.
I have some more, Your Lordship.
Is it required? If it is on the same point, I don't think it is.
Is aware of all the settled position of law, Your Lordship. So I need not burden Your Lordship with other judgment, Your Lordship.
It is not required if these are all with regard to the same propositions. Then will not.
They have to comment this one. They wanted it to be this one.
And then, if Lordship, I may also like to rely in another one, Your Lordship, and that is reported in 2003, Your Lordship, 6 SCC, page 175, Your Lordship, in paragraph 20 of that judgment, Your Lordship.
2003, 6 SCC.
Yes, Your Lordship, 6 SCC, 175, para 20 of that judgment, Your Lordship.
What does it say?
Lordship, it says like this: it is well settled that a first information report is not an encyclopedia, which must disclose all facts and detail relating to the offence.
It's all right. See, like this is, for in what context goes passes it, those kind of observation depends. You see, like in 482, what is relevant, and for other purposes, there may be these things. Anyway, these are, I think, basic propositions. Okay, FIR is not even a conclusive proof also. It's not a conclusive proof also.
So, my humble and respectful submission, Your Lordship, to conclude, Your Lordship, is considering the fact, Your Lordship, that those documents which have been annexed in the petition, which I have pointed out before this honorable court, Your Lordship, appear to be forged or fake, Your Lordship. In my humble and respectful submission, Your Lordship, a person who comes to the court must come with a clean hand.
Yes.
Must come with a clean hand, and if he does not come with a clean hand, or with clean hands, Your Lordship, that person is not entitled to any relief from the law. So, my humble and respectful submission, Your Lordship, is
any decision to support your contention?
Lordship.
Any decision to support your contention?
Clean hand, Your Lordship. Yes, with clean hand. Lordship, Lordship will have to give me some more time.
It's okay. It's all right. It's all right.
Decision are there, Lordship, that even in taking the principle from the writ petition also, Your Lordship, those who
no, these are basic propositions.
Yes.
No, sir.
So, my humble and respectful submission, Your Lordship, the criminal petition is liable to be rejected and dismissed, Your Lordship.
Yes. I think yes. Now I think this is over so far as the respondents are concerned.
Yes.
Mr. 1 second, Mr. Bhuiya, you have anything more to say?
May I make a statement?
Before the senior counsel starts?
My lord, I would be right. My lord, yes, my lord, yes.
You have already finished. You have already finished.
My learned colleague has already. Yeah. That is only one line of the particular judgment is very important, my lord.
Yes.
And the example that has been given in that particular paragraph 20 is very important.
Which
and
judgment?
again, rereading it, my lord. It is well settled that a first information report.
No, which you are referring to which judgment?
2003, Your Lordship, most probably. The one which I have last judgment.
2003. Yes. Yes.
2003, 6 SCC 175, Your Lordship.
Yes.
20, Your Lordship. The one just now
Paragraph 20, my lord. I'm reading some lines, my lord, and the example.
Just a minute,
given, my lord.
just a minute. What is that you said, Mr.
There is a claim.
Lordship, that is 2003.
Paragraph 20.
We have not given. We have not supplied that 2003.
I'm highly sorry.
One minute, Mr. Bhuya. Yes.
Kindly come to para.
Yes.
At page 183, Your Lordship.
May I read it, my lord?
Yes, you are reading paragraph?
20, the same?
Wait, let him say.
20, my lord.
Yes.
These lines are very important. The words are very important.
Yes.
It is well settled that a fast information report is not an encyclopedia, comma,
Yes.
which must disclose all facts and details relating to the offence reported.
Yes.
An informant may lodge a report about the commission of an offence, though he may not know the name of the victim or his assailants. He may not even know how the occurrence took place. A fast informant needs not necessarily be an eyewitness so as to able to disclose in great detail all aspects of the offence committed. What is of significance is that the information given must disclose the commission of a cognizable offence, and the information so lodged must provide a basis for the police officer to suspect the commission of a cognizable offence. At this stage, it is enough if the police officer, on the basis of the information given, suspects the commission of a cognizable offence, and not that he must be convinced or satisfied that a cognizable offence has been committed. If he has reasons to suspect, on the basis of information received, that a cognizable offence may have been committed, he is bound to record the information and conduct an investigation. At this stage, it is also not necessary for him to satisfy himself about the truthfulness of the information. It is only after the complete investigation that he may be able to report on the truthfulness or otherwise on the information. Similarly, even the information does not furnish all the details. He must find out those details in the course of investigation and collect all the necessary evidence. This is the line, my lord.
Yes. No. Yes.
So, my lord, affair and the investigation as on today is to be looked into totality.
Yes. There has to be a disclosure of cognizable offence. That is what is
That is the principle of law.
That is yes.
Absolutely. Yes. And from, my lord, from that particular document, that is the affair itself says and been annexed, my lord, as annexure E. In the affair itself, it has been stated, my lord, that with regard to the letter dated 25/2021, wherein this person signed as a director is not a director on that day, whether it is a false document or a false document. My argument, I am reiterating it, my lord, it's a false document, my lord, because on that day he made a false declaration. And the example that I have given on the last occasion is this, that today I am not the Prime Minister, I sign a document as a Prime Minister, so it will not be a false document, and it will be a false document. And in a false document, and a false document comes within the purview of, my lord, forgery. These are two parts of it, forgery, my lord. 463 and 464. This is my limited argument, my lord.
Yes. Yes, sir. Now you can reply. You can give your reactions.
Yes. My lord, I'll deal with Mr. Bhuya's reply, and I think that will cover the argument which has been made by the learned additional advocate general.
Yes.
I'll meet some of the points which have been made by the learned advocate general. My lord, the first argument that Mr. Bhuya has made is that FIR, the present FIR, which is impugned before your lordship, is not a statement of offence, but it is an independent case. And allegations are of independent offences unrelated to Sankrail case. Now, this is the submission which has been made. I'll take your lordships to the FIR at page 18 of my petition.
That has already
The impugned FIR. And I have read it out. I'll just today read out only few lines from where I can show that this FIR is nothing but it has been filed to pressurize the accused to come to their terms. Your Lordship will kindly have paragraph 4. Paragraph 4 at
Yes.
page 18. At
Yes.
page 18,
Yes.
the last 3 lines, just last 3 lines.
Yes.
I was shocked to see the supporting documents given by Jindal along with FIR, as many documents were prima facie contradictory in nature and forced by Jindal for the benefit of its case 1144/2022. Still, Mr. Bhuiya says that it is not connected. Now, my lord, will turn to the next page. Next page, my lord.
Yes.
Paragraph 5. 4th line from the bottom, if my lord will kindly see. 4th line. This is a letter. They are referring to Ramesh Bansal letter dated 20th/5/2021. This letter is further countersigned and verified as true copy by Director Mr. Sudipta Bhowal on behalf of Jindal India Limited. Both Ramesh Bansal and Sudeep Bansal are aware of untrue act and has knowingly forged a document and submitted the same to police and honorable court in West Bengal. And still he claims that it is not connected with this FIR, the FIR that has been filed in West Bengal. Now, my lord, will come to paragraph 6. This is a small paragraph. I'll place it. Biplav Sen Gupta, employee of Jindal Limited, was responsible in 2021 for third-party inspection before the dispatch of materials from factory of Jindal in West Bengal and presently representing in PHE Meghalaya, is hiding the facts that rupees 66.79 crore pre-inspected materials has already been delivered to PHE. My lord, kindly note, I will also refer this when they say that Jindal has collected lakhs and lakhs of rupees on the basis of forged bills. I'll refer this, your lordship kindly mark it. Biplav Sen Gupta is hiding the fact that 16.7 crore pre-inspected materials has already been delivered to PHE from the said missing material, and payments has also been received by Jindal in its official bank. For many of the alleged missing consignment, despite receiving the payment from PHE, your lordship will kindly see, in respect of missing consignment, he says, they have made a criminal conspiracy against me for falsely accusing me of alleged theft of 69.79 crores. Where it is? It is in the first information report. We have alleged that he has misappropriated. This is his FIR. My lord will just 2 more paragraphs, small ones. Paragraph 7, if my lord will kindly see. Since Jindal was aware of actual delivery of location in the said missing truck, they have paid many freight bills of alleged missing truck to the said transporter even up to 2022. But despite making freight payments to transporter, they chose to file this misleading FIR. And yet this FIR is not connected with the FIR that has been filed in Calcutta, according to Mr. Bhuiya. Now the next page, your lordship will see. 10. Jindal is trying to threaten us through their West Bengal FIR 1144/2022 that if we do not take back NCLT case against them, then they will get us falsely implicated in West Bengal FIR. They will deny all authorization given to us and straightway deny all our doings in PHE Meghalaya and get us behind the bar. Then, my marriage ceremony scheduled on 1/2/2023. The FIR was lodged on 1/11/2022, my lord. Our FIR in West Bengal, which got cancelled due to filing of this untrue case by Jindal. I pray to Meghalaya police to kindly register FIR in the said matter as early as possible and begin investigation of the forged documents and misleading facts given by Jindal India. Where did we give this misleading fact? He is referring to the FIR that we have filed before Sankrail Police Station.
Yes.
Therefore, Miller, my submission is just one line. This FIR cannot be divorced from the FIR that has been filed by the petitioner before your lordship. Now I'll come to the forgery part.
Yes.
Now it is alleged that we have forged the document, and my lord, the respondents have referred to page 63, 64, 67, 84, 86, and 92 of the. I'll take your lordship's one by one. I'll not read it, I'll not replace it, I'll just place one vital fact.
Yes.
Now I'll take your lordship first to page 51 of my petition, my lord.
What is that?
Page 51. Now, this is my lord.
Yes.
CRA Calcutta. There's a criminal revision application number 1 of 2023. This was filed before Calcutta High Court.
Yes.
This was called modification of the interim order because they had obtained an interim order from Calcutta. So we filed this. This is the brother of the informant, respondent number 2. He's the brother, he's not a party here. In this application, we have annexed these documents, which your lordship will get at page 63, which is said to be forced, which your lordship has already seen. This is bill dated 12/8/2021. They have already, Mr. Bhuiyan had referred. So this is part of the miscellaneous application that was filed by us in Calcutta. Similarly, at page 64, my lord will see what is false here. This is a challan which was supposed to be given to us after receipt of materials by PHE. Then my lord will come to page 67.
These are all parts of that
Yes.
application for vacating the modification.
Yes, my lord. Yes, my lord.
Yes, yes.
Then, my lord, you see the second line, document which they are saying is false. Your lordship will kindly come to page 63, my lord.
Page
73, my lord. 73.
Yes.
73, your lordship will see this is criminal revision application number 2 of 2023. This was filed in Calcutta for vacation of the interim order, which was obtained by the informant. He is the informant, my lord. He is the informant, and your lordship will see at 84. This is a document that they have shown. That this is a forced document. Then, my lord will.
Yes, one. Please give me one.
My lord will go to 86.
Yes, you are referring to 84. You refer to 84.
84. They have referred, my lord. This is part of the application which was filed before Calcutta High Court. And filed by us.
Yes, then 84 and then come
Then,
to...
my lord, 86. 86.
Yes.
86. This is bill. This is also part of that. Criminal revision application number 2 of 2023. Then similarly 92. Similarly, 92.
Yes.
Is also filed before the Calcutta High Court in Criminal Division Application number 2 of 2023.
Yes.
Now, there are some documents which have been referred, 3 documents which have been referred by them, which are there in their counter affidavit. Oh, my lord, one thing your lordship may kindly note, both these criminal review applications filed before Calcutta High Court were filed on 4th of April 2023. Your lordship will kindly come to page 59. This is the application, my lord. 51 starts, and then your lordship will come to page 59.
I think this here.
59. This is the last page of the criminal revision application number 1 of 2023.
Yes, 4th April.
4th.
Yes.
Then the next one starts from 73, and the last page at page 81. My lord will see this is also 4th April 2023.
Yes.
Now, my lord, their FIR is 14/4 after this. But they have not made any amendment in the FIR that these are the 4 documents. Subsequently, they are saying.
In page 73, who is the petitioner in the criminal revision application?
My lord, we are the petitioner in both. In both.
You are the petitioners.
Yes, my lord. We have filed this application.
Yes.
Jindal India Limited applicant. We have filed, we annexed these documents, which they claim that it is forced. And we filed it before Calcutta High Court.
Yes.
Now, my lord, there are 3 documents which the respondent have annexed in their counter affidavit. It's in the counter affidavit of respondent number 2.
Yes.
Page 30, your lordship will see the left side, it is alleged that it is forced. On the right side, your lordship will see it is signed by the EE, Executive Engineer Store Division, who receives, my lord, without him, no payments can be made.
Page 30.
On the right hand side of page 30.
Yes.
Right hand side, your lordship will see senior engineer, executive engineer should be, or senior engineer, PHE Store Division. My lord, got it at page 30.
Yes.
It's verified.
Yes.
Then, my lord, they are referring to paragraph page 33. Page 33.
Yes.
This
There
is a
also.
bill. This has been designed by junior engineer.
Yes.
Junior engineer PhD.
No, but then whether these signatures are genuine or not, is it for us to determine? You see, how we'll know it is?
No, what I'm saying is
that is the question, my lord. That is the moot question.
Please let me say, Mr. Bhuya, you too, let me just finish. After that, I'll go away.
I'm sorry. Yes, I will take a clarification.
Whether the signatures are genuine or forced, it is they who say that these signatures are forced. I am just showing that the documents which they are alleging that it is forced is countersigned by the PhD junior engineer. Whatever it may, your lordship will see the date of all these three documents. The date of the document, one is 21/6/2021 at page 30. I'll just place why these dates will be important. 30, your lordship will see the bill dated 21/6/2021. This is page 30.
Yes.
On top of it, yes, 21/6/2021.
Yes.
Then, my lord, will see at page 33. Page 33.
Yes.
Page 33. This is 11/10/2021.
Yes.
Then the last one, page 51. This is 23/8/2021.
Yes. Yes.
My lord, I am on the point because the law is very settled. There is no dispute. I will not dispute that if without adding or subtracting a case is made out, then your lordship will not interfere. And the second Bhajanlal says if there is a bar or if it is attended with mala fide. These are the points which is given in the Bhajanlal case, which is still a leading case in the point. Now, my lord will kindly see page this 51, my lord, paragraph 20 of their counter affidavit.
Now, these dates, which way it becomes relevant?
Yes, I'll write. It becomes relevant if your lordship goes to my FIR that we have filed in Calcutta, in Calcutta. It becomes relevant. My lord, kindly turn to page 43. Page 43. Page 43, paragraph 13. Paragraph 13.
Yes.
In fact, I placed, but today, since they have already made their submission, then placing it will be more relevant today. Paragraph 13 is, as and when the materials have been dispatched from your petitioner's manufacturing unit, corresponding invoices were raised on PHE. However, payments were withheld till about April 2022. Kindly note this. In April 2022, PHED informed that they were unable to make any payments whatsoever because they have not received majority of the materials. More particularly, the materials mentioned in the above table entrusted to accused 1, 2, 3 pertaining only to these are transporters, Jawai division. On the contrary, they clearly refuse to make any payment unless the aforesaid goods are supplied to them. Because PHE will not give payment. I'll come to that. That will be a separate point. PHE will not give payment unless the materials are received by them. Now, if my lord will see at page 51, my lord.
51 of?
Sorry, I'm sorry. Next para. Or let me complete it. In April 2022, PHED informed that they were unable to make any payments for, I have already placed it.
Yes.
Now 14. Your petitioner was completely shocked and surprised to receive the letter from PHED. Your petitioner immediately consulted the records and pulled out relevant consignment of lorry challan relating to the consignment that were allegedly not received by PHE that has been returned by the accused persons with the endorsement of the recipient. The petitioner was aghast to note that none of the consignment lorry challan before stamps of its board stamp or signature of the authorized representative of PHED. On the contrary, some of those were unsigned and unstamped, while others bore some scribbles or illegal signature. In the light of such evidence, all the representative of the accused person, accused number 4 to 6, were called and confronted them with a letter received from PHED and the aforesaid consignment notes lorry challans they were supplied by the respective accused persons. After much persuasion, the accused 4 to 6 confessed that they have handed over lorry challans along with the materials to various persons other than at the specified destination of PHED as per direction of accused number 7 and 8. Accused number 7 is respondent number 2 here. As they were very close to the then management of the company who were at the helms of affair till August 2021. Name of the accused person number 9, the then marketing head of the complainant petitioner, also came up during discussion on being persons who were instrumental in issuing directions to the accused persons regarding the place and delivery of the materials. They confessed that they have instruction from the accused number 9 that they were to call accused 7 and 8. This is point number 2. As soon as they cross into Meghalaya, and there they will deliver the entrusted good at a place at their instructions. There was destination different from the ones designated in the lorry challan. The accused persons have confirmed such a statement in email sent to the petition. So they were there, my lord. The earlier management was there till August 2021. And these gentlemen, they continued, my lord. And it's admitted by them in their FIR. You know, kindly see at page 18, they have admitted. At page 18, my lord, of my petition, there is a clear admission.
Yes.
I was appointed as authorized commission agent by Jindal to represent them in PHE Meghalaya for getting materials cleared at the consignee end and to get payment released to Jindal India bank account from PHE at an early date. Our authorization certificate was signed and executed by employee of Jindal India, Sri Ravi Shukla, in the month of so-and-so, so-and-so. Ravi Shukla is arrested by the police. We have made a mention in our counter. Our affidavit in reply. Your Lordship will kindly have my affidavit in reply.
Do you really go to all those exercises for deciding this application?
No, I'm not. My lord, I am not disputing anything. What I am trying to say, this is a false and fabricated FIR set in motion to frustrate our case there in Calcutta, in West Bengal. And nothing but it is abuse of process of the law, my lord, that this has been filed. I'm only for that purpose I'm taking your lordship. That it's an admitted, I'll not take your lordship to affidavit in reply. It is an admitted position that they were our agents. They were our agents in Meghalaya.
Yes.
And marketing manager says you to the lorry instruct lorry drivers to deliver the material as per the instruction of respondent number 2 and his brother. And that was done. Now to wriggle out of it, they have filed this a sort of counter FIR. And all those documents were there on record in Calcutta High Court. Before they filed their FIR, they have not annexed. In the FIR, my lord, they are referring to 7 documents. The lordship will see which have not been annexed. We tried to get the certified copy. We were given the copy of the FIR, but said that annexures are not there. Annexures are not there. Now, my lord, your lordship will see the other submission.
Yes.
One of the other submissions which have been made is that Jindal received lakhs of rupees from PHA department. This was yesterday said on the basis of forged and false document. So in order to make out a case, in the first information report, they are alleging that Jindal have received lakhs and lakhs of rupees. And this is not in the FIR. This has been, my lord.
No, we will go by the FIR. We will not go by what they say here.
Yes.
The allegations which they are making here.
My lord, for a moment, if your lordship permit me, I will just say, because, my lord, there is a saying that one should not treat the path where angel fears. Now, if they say that by placing these forged bills, we receive the payment as if it is available across the table, that we give forged bill and they give us check. It is not. There are procedures for payment. And right from, my lord, the storekeeper up to the person who has the authority to sanction payment, that is commissioner and secretary, such huge amount. And they are all concerned. And unless there is an allegation that they are also hand in gloves with us in defalcation of this money, this FIR will not lie at all. There is no question of anyone, my lord, taking payment without supply of the materials. These are just, my lord, a fiction of a fertile mind. Now, my learned friend, my lord, referred to Anjum Chaudhary's case. This case is related to the present chief minister of, his name comes in, I saw, Yogi Adityanath. He referred to paragraph 25, wherein says that on different incident, different FIR can be lodged. I don't dispute that proposition. But is the FIR different? Does it disclose a different cause of action independent of the FIR that we have filed there?
Yes.
In my humble submission, my lord, the answer is no. They are repeatedly referred to the FIR that we have filed in West Bengal. Then, my lord, the other argument which my learned friend made, give by way of an example, that suppose the police is investigating a murder case, a case under 302, and they recovered the weapons later on, and they can add Arms Act. They can add an offence under Arms Act. Yes, they can. Why not? Who can dispute that? But, my lord, first of all, Section 156 of the CRPC, your lordship has gone many times. An FIR must disclose a cognizable offence. That is the prerequisite of setting in motion an investigation by the police. That is, my lord, if your lordship will like to see a 156,
Yes, yes.
just show me, lord.
Yes.
156, my lord.
I have already referred yesterday.
An officer in charge of a police station may, without the order of the magistrate, investigate any cognizable offence which the court having jurisdiction over the area within limit of such station would have power to inquire or try under the provision of chapter 13. Now, therefore, the first requisition is that the offence must be disclosed, and not only disclosed, it must be a cognizable offence. Only then the police can set its machinery in motion. 302, yes, it's a cognizable offence. There must be evidence. The police has proceeded, and then they found that maybe the weapon used was a gun without license. They will register a case under Arms Act in the same FIR, in the same proceeding. There is no dispute. But is this a case, my lord, where, my lord, there is no basis for even proceeding with the investigation, even registering the case? There is absolutely no basis. What are they alleging? My lord, they did not say, as your lordship has pointed out, that your lordship will not go into whether money we have received or we have not received. But what is their case? They say that a letter is given by one Ramesh Bansal. He signed as director, but he was not a director at that point in time. Therefore, this is a false document. Merely having, my lord, I am not disputing. Suppose I admit for a moment that he was not a director as on the date when he has written that letter. That letter I have produced before your lordship. It is annexed with their counter affidavit. It says, informs the PHE authority regarding delay of the materials because of the COVID. Yesterday I placed it before your lordship. If your lordship likes, I can show that.
Yes, please go ahead.
My lord, I don't want to repeat, my lord, therefore I am asking. Your lordship will kindly have their counter affidavit. Their affidavit.
Yes.
The letter dated 20th 5/2021. When these, page 15, my lord, annexure 3. This is the letter which you say. This is the only allegation in the first information report. This is a letter by which we informed the chief engineer PHE that there is a delay in supply because of the COVID. They say this constitutes an offence under 469. I am at my wit's end, my lord.
You're referring
how
to
my information and anybody information regarding delay in supply.
Their opposition.
Yes. Yes, yes.
This is a letter, my lord, addressed to Chief Engineer PHE regarding the COVID address.
It was not there, yeah.
Yes.
So this is the only thing which they have placed and say that this constitutes a case under 469. So if, my lord, informing PHE will constitute an offence of making a false document, I don't know. So there must be a purpose for making a false document or a false document or forging a document. There must be purpose. It can't be in abstract.
Yes.
The respondent number 2 is, my lord, desperate to make out a case. 469. I have placed yesterday, my lord, 469, which says forgery for harming reputation.
Yes.
I ask you a question: how does this letter harms the reputation of respondent number 2? I am informing there is COVID, we are unable to supply. He says my reputation is harmed, and police registers a case. And again, at the cost of repetition, my lord, I'll submit before your lordship that approaching police at Sankrail in West Bengal cannot be said to be a criminal conspiracy or a criminal act with common intention. We have approached the lawful authority. We lost crores of rupees, my lord, because they have diverted. And we have filed an FIR. And then this FIR, present FIR, which is impugned before your lordship, they say that there is a letter which harms our reputation. That's the only thing, that FIR doesn't disclose anything else.
Yes.
Now, my lord, I'll come to the sections which they have referred. Your lordship will kindly see page section 463 of the Indian Penal Code. In any case, the FIR was not registered either under 463, 465 or 464. It was or 468 or 471 as is now being said. It was registered under 469.
That is not required. That is not required.
Please don't make comments.
These are the definitions. Yes, yes, yes.
My lord will kindly see 463.
Yes, yes.
It's forgery. Whoever makes any false document or false electronic record or part of a document or electronic record with intent to cause damage or injury, this is a sine qua non. An innocuous letter being sent by one of our officers that due to COVID we cannot supply, and they say it is harming our reputation. What is the intention behind sending that reputation, that letter? With intent to cause damage or injury to the public or to any person or to support any claim or title or to cause any person to part with property or to enter into express or implied contract or with intent to commit fraud, or that fraud may be commits a forgery. So by letter dated 20th 5, 2021, whether these are intended to be committed, because that's the only allegation in FIR.
Yes.
Then my lord will.
Yes, proceed, please. Yes.
So no made out under 463. Absolutely no case is made out. Then my lord will come to 464. Making a false document. A person is said to make a false document or a false electronic record who dishonestly or fraudulently. My lord, dishonestly word is defined under section 24 of the Indian Penal Code. Kindly, my lord, look into, kindly come to my lord, section 24 of the Indian Penal Code.
Yes.
Dishonestly.
Yes, please. Yes, please.
Whoever does anything with intention of causing wrongful gain to one person or wrongful loss to another person is said to do that thing dishonestly. So the purpose of making a false document is to cause wrongful gain or wrongful loss. What wrongful gain and wrongful loss was caused to respondent number 2, only he can tell. Even he cannot tell. He has not said. who dishonestly or fraudulently makes, signs, seals, or execute a document or part of a document, makes or transmits any electronic record or part of any electronic record, affixes any electronic signature on any electronic record, makes any mark denoting the execution of a document or the authenticity of the electronic signature with intention of causing it to be believed that such documents or part of documents or electronic record or electronic signature was made, signed, sealed, and executed, transmitted, affixed by or by authority of a person by whom or by whose authority he knows that it was not made, signed, sealed, or executed or affixed. Then, my lord, the explanations is there, second and third, not relevant. But my submission is, my lord, whether letter dated 20th of May 2021, which they have annexed, and on the basis of which they say that it has harmed our reputation, whether that letter will meet the requirement of 463 or 464. It will be certainly not. It doesn't meet. Then, my lord, my learned friend, Mr. A.A.G. Melot has referred to today 467, 469, 469 I've already said, and 471. My lord will kindly come to 467. 467. Whoever forges a document which purports to valuable security or a will or an authority to adopt a son, or which purports to give authority to any person to make or transfer any valuable security, or to receive the principal, interest, or dividend thereon, or to receive or deliver any money, movable property, or valuable security, or any document purporting to be an acquittance or receipt of acknowledging the payment of money or acquittance or receipt for the delivery of any movable property or valuable security shall be punished with imprisonment for either description for a term which may extend to 10 years and also fine. Then surely, my lord, no case is made out under this. I don't have to go in detail. 46171, my lord. Using genuine as genuine a forged document or electronic record, whosoever fraudulently or dishonestly uses any genuine or document or electronic record which he knows or has reason to believe to be forged, the documents or electronic record shall be punished in the same manner as if he has forged such documents or electronic record. My humble submission is, my lord, no case is made out by this FIR. Absolutely no case. Then, my lord, your lordship will, I'll not take much of your lordship's time. In the cause list, if your lordship will see, there is a case listed, miscellaneous case filed by the state, in the cause list.
Yes.
May it please your lordship.
This is
what is being heard finally.
Prohibition 73
yes.
of 2020 is filed by them.
Yes.
And your lordship will kindly see the date. It is filed on 3rd of October 2023.
Yes, 3rd October, yes.
3rd October.
Yes.
Your lordship will find there is not even a whisper regarding when they have seized, whether they have seized, when the case was converted into 467, 460, 460 and 470. There is not even a whisper. And your lordship will kindly see the case, your Lordship will see the case diary. I have no access to it. But what is found in the case diary, in case there is an effort to embellish the allegations, your Lordship will see that it will not be paginated. The diary will not be paginated. Because diary is supposed to be paginated and regularly maintained.
Yes.
And my lord, the further argument will be that if they have any counterclaim,
Yes.
my lord, will know TT and Thani's case. TT and Thani's case was in 2001. I made a reference. I'll not refer. It was by K.T. Thomas, that judgment was. And the judgment said that if it is not a counter case, then the two FIRs cannot be lodged on the same facts. If it is lodged, it will be struck down. But how that case was misunderstood, that two FIRs cannot be lodged. But that was not so. The court itself clarified. Then, my lord, subsequently they say, very clearly say, in Kari Chaudhry's case, that my learned friend will hand over, my lord. This is 2002, 1 SCC 714. That's right.
Yes.
This is also by just K.T. Thomas Miller at page 714.
Yes.
My lord will kindly come to page paragraph 11 at page 717. 717.
Yes.
My lord, fifth line from the top is the law which has been laid down, the ratio of the judgment.
Yes.
But when there are rival versions in respect of the same episode or incident, there would normally take the shape of two different FIRs, and investigation can be carried out on both of them by the same investigating agency. If they have any counter claim, or if they say that no, the FIR is wrong, please go to them, point out, they will investigate. Like my lord must have come across so many cases, counter cases in civil, my lord, has to be tried by the same court. What is important is that two FIRs can be filed, and it has to be investigated by the same agency if it relates to the same transactions, same episode. If at all they have, they don't have, but if at all they have, then they have to go there. And my lord, another thing which I would definitely have already said, that there cannot be any payment without supply of material. If it was there, the PHA department would not have stopped our payment. They have not only stopped, I have shown from the FIR that we have filed in Sankrail police station. They have not only stopped, my lord, payment which are pending. They say you have not supplied the materials. And now to allege that we have drawn lakhs and lakhs of rupees, this is out of the blue. It is not in the FIR. So therefore, my lord, my humble submission would be that the first information report, even if taken it's on the face value, does not make out a case. And if they have any counter claim, they have to go before Central Police Station and agitate there. Or they can take, as your lordship on the first day pointed out, this is a defense. They can take up it is open for them to go. But to harass, my lord, the entire company, it's a public limited company. It's a public limited company, and leveling allegation that we are drawing money. In somewhere, my lord, see, it's not that the amount which has been withheld is 0.01% of the total turnover of the company. So therefore, my lord, level these allegations, at least they'll have to be responsible. Respondent number 2 have to be responsible what he's saying. It doesn't make out the case, and therefore, and my lord, maybe for your lordship, that the FIR be quashed.
Yes.
I'm grateful, my lord, for giving me this
pleasure hearing you.
patient here. Now, my lord, there is a saying, give bite to Mr. Bhuya, and Mr. Bhuya will not stop. So I'll take my lord.
I have heard you patiently. Senior counsel, we learn from the seniors. Every day is a learning day for everyone.
We learn from each other. My lord, may I leave your lordship's permission?
Yes, please.
All right.
I'll only reply with regard to my lord the no.
Again, reply against reply. No,
my lord.
Who will reply you
not
again,
reply.
Mr. Bhuya?
Already I have with regard to certain things that has been pointed out for the first time during argument. That, my lord, the learned senior counsel, Mr. Mishra, we have pointed out certain documents with regard to his previous litigation between the parties in Calcutta. These were the documents when it has been filed, my lord has noted it down. These on 4/12/2023. Now these documents were forged documents, and when it came to my knowledge, my lord, then I filed the FIR, my lord, subsequently thereto, my lord. That is, my lord, the FIR that has been lodged by us is subsequently thereto. When I discovered these are documents that has been forged, including that particular document at page 15 of our affidavit in opposition, which is part of the FIR. And my lord, all submissions been made, but this has not been replied to the satisfaction of this honorable court, whether Mr. Ramesh Bansal was a director on 25/2021 or not, because he was not there. So admittedly, they are admitting that these are false documents. And my lord will kindly see their writ petition itself, their criminal petition itself, my lord. We have stated that these are the documents which are false documents, my lord. And these are false or true, my lord, is evident from the RTI reply I have received, my lord will kindly take up.
You have placed all those things on the other day, Mr. Bhuya. You placed all those things on the
one thing I just pointed out, and one answer will, my lord, demolish all of the argument. That's what I am placing it.
Yes.
That these are genuine documents according to them. At page 26, my lord, affidavit in opposition. Page 20, RTI reply. Kindly see the list. This is RTI reply. Actual date of receipt of these bills. Date is different. Values, IGST, take value, 22/11/2022, vouchers and dates. This does not match. And here the document comes out.
see, these are the problem. You
And
see,
here
like
a
these are.
document comes out wherein my forced signature appears. And these are admitted by them that these documents they have submitted in Calcutta proceedings. But whether these are forced document or not, this is the subject matter of the instant case.
It's all right. You have said it. You have
And
said
I have to know. Yes. That I am sticking to it, to my argument, my lord. I will not waste the valuable time of the court. And here is a case wherein it's an open and shut case, my lord. And the goose of being an influential person and point person, nobody get the license to be above law, my lord. And way to laws and affair is the discretion of the person aggrieved, my lord. And that has been laid down in chapter 13 of the, my lord, CRPC, my lord. Cause of action arises here, my lord. That's what I was repeating. Chapter 13, my lord will kindly take up Evidence Act. One section I am putting it to your lordship. Section 17, my lord, of the Evidence Act.
Section
17, my lord. My lord, admission has been defined. A statement, oral or documentary, which suggests any inference as to fact in issue or relevant fact is an admission. Now, learned senior counsel has
evidence should when evidence will come into play. No,
my lord,
admission and all, it's before the court.
Advanced before this honorable court. Absolutely. But the submission that has been advanced before this honorable court, that these are the documents submitted in the Calcutta, my lord, before the Calcutta authorities or the court of law, which are forced. And this is the subject matter with regard to, my lord, the investigation part, where I came to my knowledge that these are the documents and these are admissions being made. Now, my lord will kindly come to the jurisdiction of criminal courts and inquiry and trials. Where the jurisdiction will lie? 177, my lord, 178. My lord, A will kindly see. When it is uncertain in which several local areas an offence has been committed. These bills were presented at, my lord, Meghalaya, my lord. Where an offence is committed partly in one locality or partly in another, or where an offence is continuing one and continues to be committed in more local areas than one, or where it considers several acts done in
these are not the issues here. See, these are not the issues here. These are not the issues here. You see, like jurisdictional part and all those things, it has not been argued.
Yes, my lord, that has not been there. Even then, I have pointed out that they have submitted that I have to file a counter affair in there. They will not decide.
No, that is because of the fact that they say that it is a statement of defense in relation to the FIR filed by them in West Bengal. That is what. Otherwise, nothing has been said on jurisdiction.
Absolutely, my lord. Clarity. There is a clarity, my lord. That is an open and shut case. These are false documents and false documents.
This idea.
I wind up my argument here, my lord.
Yes. Thank you, Mr. That paragraph 11, which was referred. Now, the senior counsel was reading some lines which this court did not get in that paragraph 7, in that Kari Chaudhary case. This is what has been referred, isn't it? 2002-1 is 714.
These facts were totally different, my lord. It's a final report being submitted. No FIR can be lodged, my lord. Only way of an appeal or otherwise, my lord. Page 717, paragraph 11, my lord.
Yes.
If a FIR ended in final report, second FIR was lost. So he said, no, law doesn't permit it. If you are aggrieved, you file an Narazgi petition. If you are aggrieved,
it's all right. It's all right.
That's the law. I'm obliged by that.
Lordship will require a case diary.
Case diary, you see, like, I don't think this.
Lordship, the decision also is there. High Court decision.
No,
Regarding
but
those
see, like, I do not know how long this court will take to deliver the judgment. Case diary, if it is written for 2-3 days, is all right. But then it is more than that.
The documents which that is Annexure 25.
See, Mr. Shulai, the court was more interested to see the FIR in exact form in which it was filed. That is what the desire of the court. That is what the desire of the court.
My lord, even yesterday I sent my person, my lord. We checked the court record, only 3 pages of FIR in the court record.
See, even the CD, now Mr. Shulai has placed this, it contains some documents, but then the FIR is not there. So, which way we can presume that these are part of the.
Lordship, that is very clear, Your Lordship. Annexure A, B.
That is clear to you, but then it is not clear to the court, Mr. Shulai. Because you will go by the statement of your clients, but then this court may not go.
Then, Your Lordship,
the basic purpose of calling for the CD and then, but then is the copy of the FIR, if it is retained in the file also, but then copy should have been there. Why your CD does not have that copy of the FIR?
Lordship, because yesterday what the court want is those document annexed with the FIR, Lordship.
No, do you wanted FIR?
Here,
no.
Already here in the criminal petition. That is why.
We can say, we'll say that CD was produced, but then FIR was missing. That we will record. The FIR is not there.
The FIR is here only before in the criminal petition.
No, but then in the CD it was not there. We'll say CD was not there.
Because
in CD it is not there.
It is here, Your Lordship.
The FIR is not there.
Lordship, those documents which has been mentioned in the FIR.
I'm asking about the FIR.
Because, Lordship, because
that is what court is trying to see. I do not know why Mr. Shulai is not understanding that part. You see, like the court is trying to see precisely.
I understand. I got what the Lordship desire, Lordship. They understand. Yesterday it was made that since those annexures are not part of the criminal petition, that's why these documents are being being produced today, Your Lordship. Those documents.
See, it was.
Mr. Shulai, complete court is asking for the complete FIR with the annexes. Produce this.
That is
This is the one, Your Lordship.
That's what this court is asking for.
Yes.
Just produce it.
What is? It has a FIR.
Case diary, FIR and the exhibits and the annexures.
FIR is there or no?
Is asking for.
You have given it to us, Mr. Shulai. This court did not say FIR.
The FIR, Your Lordship, because what happened? The FIR.
It is not there. That is enough. You see, you do not have to give any explanation.
These are the documents.
We do not need to see the documents. What we wanted to see whether FIR really contains the documents. So we'll record in that he was produced.
We can produce everything, Your Lordship.
No, but then you see, Shidu should have it. Why it is not there?
No, it is there, Your Lordship. It is not. Even the sexual list also is here, Your Lordship.
It is not there, then you say it is here.
It is here. It is there, Your Lordship. Then Lordship will by tomorrow I'll produce it, Your Lordship.
No, it is not required. So let's say, like, you have produced CD, we will record it and we will say it, because if this FIR is not there, that is what we will say.
Tomorrow, Then tomorrow, Your Lordship. Tomorrow.
No, it is.
We'll make the complete case diary tomorrow, Your Lordship.
No, we'll. It is not needed. See, like. This is how it should have been produced. I do not know how a CD comes without a copy of FIR. Police doesn't retain a copy of FIR with them for the purpose of investigation.
I can produce it tomorrow, Your Lordship.
Forget about your thing, your part, Mr. Shulai. You are not things. How police maintains a CD without copy of FIR? How they are conducting their day-to-day investigation without FIR?
But the fact remains,
produce the whole.
Those documents which I have pointed out, those are sealed documents, Your Lordship. These are the annexure of the FIR, the documents seized by the police during the course
right now, court doesn't have any intention to go and scrutinize all those documents. Because that is the business of the court at this stage, especially in a 482 question.
Yeah. You produce all of the CD.
This is
that
only
includes the FIR and the annexure.
punishable offence. Then Your Lordship will not exercise that 482 power, Your Lordship. Then the fact
that's a different issue. Court is asking for
remains, Your Lordship, that those documents which they have annexed in the petition are either forged or fake, Your Lordship. So in that view of the matter, Your Lordship, Lordship will decline to grant any relief to them, Your Lordship. I have pointed out, Your Lordship, from document seized by the police, Your Lordship, that these documents are either forged or fake.
But then there is no scissor list.
A scissor list is here, Your Lordship.
Scissor list is there.
Yes, it is there. This is the scissor list seized on 18/6/23. Your Lordship.
How many documents you have seized?
Lordship, a lot of documents, but
how much your scissor list is how many?
Lordship, I'll have to count, Lordship. 60,
Scissor list, it is not maintained that way.
61, then
Plus
11,
11,
13, then 41.
It is by different scissor list.
Lordship, yes.
Anyway, it's all right. It's all right.
So far, that annexure 25, which I have shown before Your Lordship, this is the scissor list, Your Lordship. It was seized on 18/6/2023. Lordship, kindly.
What is this? This is one scissor list.
That is scissor list, Your Lordship.
It doesn't speak about so many documents.
Lordship, the documents are.
That is okay. So we do not want to see documents. You say like court will not go into all those things.
This one is only with regard to that.
Anyway,
annexure
that
25, Your Lordship.
it's all right. As per the last order. What is the order? Last order in this. As per the order dated 9/10/2023, Mr. N.D. Shulai, Learned AIG, produced the case diary, produced the relevant case diary. Stop. The same was perused and returned back to him. Stop. Give a stop. Heard the parties. Judgment reserved.
Deep down. Apply, Your Lordship.
Mainness,
No, apply.
item number 1.
Yes, yes. Yes.
Sanjay. Sanjay.
I filed the affidavit in opposition. I filed the affidavit.
You filed your affidavit in opposition. So matter is ready for hearing or?
2 weeks for filing of a rejoinder.
Yes, yes. No.
A rejoinder.
Yes. State is not filing an affidavit.
So far, the state, Your Lordship, on the basis of the material made in the petition, Your Lordship, as well as in the affidavit filed by the private.
Will not file any affidavit supporting the petitioner.
Because what happened, Your Lordship, the state was not a party before the Lok Ayukta, Your Lordship. So whatever material or records are available in the petition as well as in the, I'll make my argument on that basis.
So you will not, will record state will not file any.
Lordship, yes.
Okay. Mr. Petitioner, Learned Counsel appearing for the resolution number 2 submits the affidavit in opposition on behalf of the resolution number 2 has been filed. Mr. Shulai, Learned Counsel appearing for the respondent number?
A state for the state, Your Lordship. Respond R1, Your Lordship.
Respondent
R1.
One submits that the state would not file any affidavit, instead would rely on the documents on record
Lordship,
at the time of hearing.
Lordship.
Mr. Pandey, Learned Counsel appearing for the petitioner praise for grant of 2 weeks time for filing a rejoinder to the affidavit in opposition filed by the resolution number 2. Period allowed. List after 2 weeks.
Highly obliged.
Item number 2.
Same, Your Lordship.
No, Lordship, here it is item number 3, Your Lordship. The petitioner, they have filed the additional affidavit without taking the permission notice.
No, I had taken permission from your
It
Lordship
is not
on the last
reflected in the order.
occasion. It was not.
Additional affidavit in respect of what?
My lord, if your Lordship recollects, this petition was drafted in a manner that only one petitioner is going to file. And then in the cause title, the names of petitioner number 2 to 10 were
It is only for the correction of the.
Yes, my lord. Just,
So
just
it will not have any material effect.
describing the status of the petitioner number 2 to 10.
Because this petition is totally confusing, because in the I have even in my preliminary objection I have make it a statement, but sometimes the petitioner is addressing himself as a contractor, sometimes he is executive member, sometimes he is saying that he is the deputy CM. Who is the deputy CM? Who is the contractor? Who is the former CM of JTTC? Because it is confusing. Because it is just a copy paste of the first petition.
No,
of course, every sentence is the same, but only if we go by the law, the detail.
Where is the petition which you filed originally? What is the thing?
My lord, in the original writ petition.
No, where is that? Has it been replaced? It is there, still part of record, isn't it? Your original application.
But
Your lordship,
and
kindly
moreover,
see-
there is
Hold on for a minute. We'll come back to you.
Your lordship will kindly see paragraph 1, my lord. My lord, in paragraph 1, we had stated that the petitioner is the deputy CEM of GHADC in 2016. He was, my lord. So,
Paragraph 1.
yes, my lord.
Yes, it starts with petitioner is member of ST community.
My lord, this petition was drafted because initially only Augustine R. Marak, the petitioner number 1, was about to file. Due to oversight, my lord, we could not rectify this portion and give the description as to what is the status of the petitioner numbers 2 to 10. That is why, my lord, your lordship had also pointed this point, and I had craved leave of this honorable court that I may be prompted to file additional affidavit. Maybe due to VC or something, my lord, it might not have been recorded. But, my lord, I have filed an additional affidavit and on last week, 5th, my lord. And I have stated in paragraph 2 that the petitioner state that initially only petitioner number 1 was about to file the case, but the petitioner numbers 2 to 10 joined later, and as such inadvertently the pleadings were filed before this honorable court in context of only the petitioner number 1. My lord, my grounds of the petition and everything will remain the same. The only thing that I have clarified here is that the petitioner numbers 2 to 9 were the executive members of GHADC in 2016, and petitioner number 10 was the secretary to the executive committee GHADC in 2016. This is the only
What is the problem, Mr. Sangma, here? Probably that should not have been done in this manner, but then what is the problem?
Whether there is no order also. And if you go by the part 9 of the petition.
Now, whether to take into the records or not, court will have some discretion, isn't it? Even if it is filed without this thing. And you see, like, it will not affect you materially. It will not have a bearing so far as your defense in the case is concerned.
But in the para 9 also he stated that he is a contractor, he is applying. That's why it's confusing.
There are 9
9 of the page.
See, why you to have so much confusion? You just withdraw, file a fresh one.
Better you withdraw and file it afresh.
The 9 he said that he is the contractor.
This is what you see, like, because you have to,
that
that way you see, like, this will remain.
Person like contractor.
Your main petition was drafted on the basis that there is only one petitioner.
It's not a contractor.
Those kind of things will remain. You just withdraw and file a fresh one.
Court cannot pass in order even in
Yes,
respective
yes, that is
better. That is better.
On the prayer made by the Lana Council for the petitioner. Miss Swan talking about Lana Council for the petitioner. Please, that she may be allowed to withdraw this petition and file afresh. Prayer allowed. The petition stands dismissed on withdrawal with a liberty as prayed for.
Lordship. First verse, Lordship.
Item number 3.
Where?
Yes.
Yes, Lordship, as per the order passed by its honorable Yes, court. Lord.
Lordship, I'm appearing for respondent number 3, Lordship.
Yes, okay, we'll enter if there is
Yes,
person.
Lordship, today I'm entering.
Do you intend to file any objection? No.
Yes, Lordship, I think because
The state? What about state?
Lordship, I'll have a case there.
Okay. MSS Nongrum. The problem is that no name, we do not know surname. That is Land Council enters appearance on behalf of respondent number 2.
3, Your Lordship.
Oh, sorry, respondent number 3. Stop. Land Council for respondent number 3. Praise for grant of. How much time you want?
2 weeks time will do.
2 weeks. Grant of 2 weeks time for enabling her to file an objection on behalf of the respondent number 3. Prayer alert. List after 2 weeks.
Okay. Highly obliged. Item number 4.
Yes, Mr. Archival, what brings you here?
In this case, Wakaratnama was filed in the morning, but they said it was in the legal side, they will not accept, so we will be filing the Wakaratnama. I am being assisted by Mr. Singh,
yes,
and Mr. Abraham is attending for the
yes.
sole respondent. We would like to know what happened, probably by mistake or whatever it may be. Our affidavit in reply, filed to the affidavit claiming privilege, was not in record. We will file it, and we are taking some preliminary objections with regard to the petition.
What is the matter about? What is the
matter was what happened? File was closed regarding some taking bribe by
contractor.
By the contractor. We are the contractor. The company was the contractor. Then ultimately the investigation was done, and charge sheet was filed. So during the investigation, certain permissions were taken from the Home Ministry, that is their case, and
phone was taken.
Phone takings were made. And ultimately charge sheet has been filed. We have appeared. We have been supplied copy. We filed an application before the trial court. Then the copy under section 207 with some copy under section 91. The application was not under section 91, but 207 some copy has to be supplied. So other copies they have supplied. One my prayer was left out, that the materials that has been placed before the Home Ministry do not obtain the permission. Okay. We are seeking that document. Now, on that document, ultimately the court says that we will hear and pass the appropriate order. Matter was heard, and the court so far claim of privilege. My submission is that S.P. Gupta versus Union of India, case 1982, was the today also. And it says that if the privilege is claimed, the court is empowered to go into the materials which they are claiming privilege.
But then if say supposing if there is a protection against production, then how court will scrutinize it?
Or that S.P. Gupta says that there cannot be any protection so far the court is concerned. I am not asked to do
that. The provision in Evidence Act, isn't it? 100,
123, 124.
Sure.
That has been analyzed in the S.P. Gupta's case.
So this will be quite interesting matter that way.
In that case, it says that court has not allowed me to see me. The accused cannot see it.
That is, see, this privilege is not only against the accused. You see, like that is even, I don't know, say supposing the privilege which a lawyer has, so far as his communication with his client is concerned, you are not bound to disclose it before the court also. If court wants, you have the privilege, not disclose it. Now, is it not that that privilege will have the same effect so far as production of document is concerned? Can it be something like that, that this is the documents will be produced before the court in sealed envelope, so that it is not accessed by the other side. But then the court will have the.
Court has to look at it. That is the what I am referring to S.P. Gupta. That is the case.
Court will see.
I am not saying otherwise. S.P. Gupta. That is.
Any counter view, Dr. Mojika, so far as that S.P. Gupta's case is concerned?
We have referred to a Delhi High Court decision.
That will not override the Supreme Court decision.
But S.P. Gupta is not. This Delhi High Court is exactly on the same.
So S.P. Gupta will be distinguished so far as this case is concerned.
Court will ultimately will not permit or not permit, but whether the court will ultimately decide, the trial court will decide whether at all the documents which they are claiming privilege are privileged document or not. If the court found that it is a privileged document, court will not close the way and
that is what. If it is a privileged document, court finds.
My lord, your
Court,
lordship,
by that time, court would already would have had this access to that.
That is, I am referring to the SP Gupta, that is a constitutional decision. That
No, you see, we are bound by that. We are not bound.
still holding the case.
These are the queries. You see, like it has nothing to do with the merit of the case.
It's all right.
You are a senior counsel. You see, like you can always enlighten us.
Lordship is giving your lordship view, my lord. Probably, my lord, we can place further materials and other things for that, my lord.
We are not. You see, this is a query. You see.
And
For us,
in fact, my lord, that decision and two other decisions were cited. My lord, that has been referred. That, my lord, the learned counsel for the petitioner has cited some decisions, but, my lord, the learned trial court did not refer to those decisions in the body of the, my lord. My lord, I have while going through yesterday, my lord, I saw that those decisions are not written. I relied on three decisions: SP Gupta, then Mr. RK.
But the decision is in your favor, so yes. That is all right. That proposition of law.
My submission at this stage that this petition is premature. Anyway, my lord, that your lordship will decide. I would like to file my lord affidavit in this time.
Definitely, please. These are interesting matters. The court also, that will be learning for the court. This will be learning for the court.
My friend will also place material.
Yes.
Because they relied on a decision which has been overruled in SP Gupta, in the petition. 1966, if I correctly remember.
We'll fix the date.
My lord, can it be on 20th?
No, but then if you have to file something, then we'll fix it after you complete your filing, and then you basically want to bring on record certain things. That is what you said, is it?
My lord, one of the affidavit and reply filed by us, that is not on record.
So you'll bring it. So you bring it on record first, then we'll fix a date for it. You can do it through somebody. You do not have to come here. You see, like for doing that. Okay, so at least there will be no trouble for you.
Fixing a date now.
After that will be better. You see, like
after 8 weeks. After 8 weeks. After 8 weeks, my lord. After 8 weeks.
After 8 weeks. Why such a long? We do not fix. We do not give such a long date. You see.
What happened, my lord, in Guwahati, my lord, we have a long vacation.
No, but then there is no problem. You just have somebody or now cease here. We are
at a time your lordship may not give. If need be, my lord, your lordship will kindly.
That is at a time we are not giving. Okay, you take 3 weeks time and subsequent it will be extended. Okay.
3 weeks will be short, man. We have a vacation there.
There is no problem. You just
4 weeks, man. If it is not inconvenient.
It's all right. It's all right. There is no question. Okay.
What we will have vacation also. We'll also have 10 days.
Yes.
10 days.
Anyway, my lord, let it be after 4 weeks.
Mr. K.
Agarwal. Long date, my lord.
Along with Mr. Singh.
BK Singh.
BK
Singh. And Mr.
Yes. Appears on behalf of respondent number?
Only sole respondent.
Yes. Appears on behalf of the sole respondent. What shall we say? What affidavit you will file? You will
basically, my lord, one affidavit in reply that was filed before the trial court. Against their affidavit claiming privilege. That is not on record. That we will file, and we have some preliminary objections to this petition.
So you will file a preliminary objection.
Plus the affidavits.
That can be brought in by these things. So we'll just say your thing. This you basically you were praying for time for filing objection in the matter. That will
yes, that will be
the London Senior Counsel appearing for the respondent. Pray for grant of some time for another respondent to file objection. File his or her his objection in the matter. Prayer allowed. List after 4 weeks.
Second call, item number 2.
Yes. What is that matter? Yes. Another CBI. Yes.
It's a new matter, my lord.
CBI has become very active. You have made them active, or?
CBI has become quite active.
My lord, I have received notice on behalf of respondent number 1 to 3 also.
So is this for motion?
Yes, sir.
It's a criminal matter, isn't it? So you have informed him before filing it.
Lordship, actually, my lord, we have filed a caveat.
Caveat in a criminal matter.
Lordship.
Under what provision of law? I do not know. This court has not come across any caveat in a criminal matter.
Provisions, Lordship, we have not given it. This filed a caveat, Lordship. It's not, the provision is not given, Lordship.
So I don't think there is any provision, but then if it is there, you can enlighten. The caveat you find in CPC, that is. Now the criminal law is there, not there. Anyway, you enter a place, there is no problem. But then this caveat to your.
I was surprised also, but when they informed me, I said, okay, this is better to serve the copy.
See, the writ petition, we follow the spirit of CPC, so there you file caveat. But then in criminal matters, there is no question of following the spirit of CPC.
On this matter, we have come against discharge of.
How office takes this caveat matters in criminal matters? The registry doesn't object for filing a caveat in a criminal matter. Is there any provision in High Court rules to that, Dr. Majiga? I don't think. This court has not come across that, but then.
Caveats are filed under 148A.
That is what?
I'll examine that as it was.
It's all right, but then what to do? See, what to do? This court is not inclined to pass any order on that.
On the caveat.
But then since it has been registered, it requires
Discharge.
to be discharged. Now that is what?
Well, I'll just go through it, Mallet. On next date.
No, but then what to do about this? Caveat.
Yeah, even pending for today, Mallet. On the next date, sure. If I can assist.
we record the appearance today and discharge the caveat tomorrow.
But they have not filed
No, but then once caveat is there, so. But then even then, I think you have put us in a difficult situation.
We'll apply this on board, my lord.
You are accepting notice, that is okay. But then what to do about this caveat? You could have appeared without caveat also, of course. You have given them advance copy because of the caveat.
Because of caveat.
So you also agree that it can be.
No, the filing did not accept, so they told me, I said, okay, we'll give you copy.
Yes. And that will save you from taking this, the hassle of taking steps and all those things.
My lord, in total there are 5 respondents, my lord. 4 and 5 are still left, my lord. I'll take steps.
This is a revision under 397.
397.
Yes, what is the matter?
Here what happened, my lord, there are certain allegations of corruption in a contract, my lord, by MES, my lord, Military Engineering Service. And the contractor, again, in collision with the government officials, my lord, there are some allegations of misappropriation of overbilling, false billing, and all those things. So, CBI filed charge sheet against 4 government officials and 1 contractor, my lord. The learned trial court only said, my lord, that there is no PC Act case made out. Discharged all 4 government officials, my lord, and framed charge only against the private person under 420 and those, and sent back the matter to CGM's Judicial Magistrates Court.
Yes. So what is the wrong with the order? Where the trial court has gone wrong?
Well, the trial court has gone wrong, my lord, basically because the clear material that government officials were in collusion, my lord. There was a conspiracy, 120B, all this, my lord. And this is a fact that false bills were submitted, my lord. Those bills were passed, amount paid to the contractor.
Oh, you have let him off. Gee, garrison engineer, you have let him off, and the subordinates you have caught them.
And these 3 accused,
That is the basis why it has come. You see.
The rule was only to deface, my lord. These accused, A1, A2, A3, my lord, they have only defaced the bill, my lord.
Okay.
And the clearing authority was the G lordship.
And that is what has been specifically recorded by the court. Why to harass? You see, like you do not catch big fish. Huh? You're not interested in catching big fish. See, you here you have recommended on the departmental action against somebody. Then can CBI do that? Recommending departmental action, they do not file charge sheet. They recommend departmental action, and that also major action, and then file charge sheet.
And my lord, interestingly, what they have done, all promotions, all benefits, everything they have got. In spite of my lord, they have been, departmental inquiry. And
They can do anything. They are very powerful. So everything is there.
And interestingly, one of the accused, my lord, he retired. Till now, he has not received, my lord, a single penny, my lord, as pension benefits. He is suffering, my lord.
Anyway, the departmental things, so we cannot go into all those things. We will be confining ourselves. But then, so now it's a revision. Do you have this thing? Can you get a revision admitted as a matter of right? Unlike an appeal. Appeal is always, it's mostly a matter of right.
Notice valid today. There is, both the parties can be heard. And if admission,
fix it after the election.
Yeah, it's all right. So once we issue notice somewhere, it will automatically come for final hearing. Anyway, hard Mr. N. Majika, Learned Counsel for the petitioner. Issue notice. Mr. Panthi. Mr. S. Panthi. Enters appearance on behalf of
1, 2, and 3.
Just one number 1, 2, and 3. And as such, no formal notice is called for in respect of the said respondents. However, the petitioner shall take steps for service of notice upon respondent number 4 and 5 within 2 days. List after initially you say the notice issued notice. Did you say anything else? No. Then down we'll just say list after 3 weeks. List after 3 weeks. Now I do not know what to do with caveat. Tell us. Since it is there, but then
I think you can withdraw it. That can be permitted.
This file made a long time back. Can it be withdrawn now?
How many days now? Already this. It remains valid for 90 days.
Yes, sir.
More than that.
July, August, September, October, 13th October. Today is what day? No, not yet. Just withdraw it. There is no problem. It will not cause you any harm.
It will not cause my lord, since I have received the notice.
You have already received a notice. You have been given these things. It is only for the purpose of receiving notice and opposing the admission, isn't it? So you were there already. Just caveat petition 99.
Can be withdrawn. Can be withdrawn.
See, what else you will do? This caveat is. That is also one question. We'll just say something. I do not know. This should not become a practice. You see, once we say that when these things and be discharged, then you will find that all criminal matters are started.
But can we just can we apply this? Can we just take instruction of you? May I just take instruction of this?
You can take instruction, but then if you file something and if you withdraw it, what is the problem?
I have no problem.
The withdrawing it, I think, is the best possible solution at this time.
Because we have come across, my lord, even my lord, in criminal cases, even the bail matters, my lord, caveats have been filed. Caveats have been filed, my lord.
Where?
Even other courts, High Court and Supreme Court also, my lord.
Probably I do not know if there is some rules permitting them to do that.
We have come across, my lord.
You don't know. Okay. But then, honestly, like I did not come across any caveat in criminal matters here.
Because this practice is
What
there.
is the
for
necessity of filing caveat? That's right. Can any interim order be passed in this kind of matters?
Why not? Stay order of stay can be passed. Imperial order can be stayed at the initial stage. Why not? May not be in the factual circumstances of this case, but then in many other cases it can be.
Other case, but in this case,
In this case,
again discharge there cannot be a stay order.
well, when their clients desire it, they can do it. So. Now, you see, like this is really, I do not know what is to be done. You see, like, I think it's better you withdraw. The caveat petition just say stands written on the prayer of the caveat. That is the best way of doing things. Send it up. There will be something. Nothing.